continuing on, talking about the arraignment process. This is where the defendant, the accused, gets an opportunity to stand before a judge, hear the charges that have been formally filed now through indictment or complaint, be advised of all of their constitutional rights to counsel, a speedy trial, and allowed to enter a plea. This starts the process. This is the last point at which the defendant has an opportunity to step away from their legal obligations until the trial process starts. Voir dire. I know I say it like a redneck. Voir dire, is merely the process of examination. I know you all, through your discussion questions, caught right away that that's how we eliminate potential jurors, is we voir dire them. We question them as to their prejudices and what have you. That's not the only place you will see that in the court system. You'll also see it when expert witnesses are going to be introduced by either side, the defense or the prosecution. They have an opportunity to question the potential expert witness to determine if, in fact, they do possess the credentials to be certified by the court as an expert witness. Generally, normally, usually, once certified as an expert witness in the court, you're an expert witness for future trials. That doesn't mean you won't be voir dired, but it means that they'll probably be shorter and shorter as you spend your time in as an expert gang witness or a correctional officer, expert witness, or whatever. See if I can get through these here for you. The exclusionary rule. This one's a biggie. It's referred to as fruits of the poisonous tree. We spend a lot of time going back and forth in our discussion questions and your readings about lawful searches. Why so much of this book on search and seizure and the rest, so little on the actual process? Because trials are all about evidence. It's not what you know, it's what you can prove. And if a particular piece of evidence cannot be introduced, you lose your case, or your case becomes much harder to prove. Basically, the exclusionary rule says that any evidence obtained or gathered through unlawful means or without proper constitutional protections, a lawful search warrant or one of the exceptions, will be excluded from use in the trial. And that's usually generally determined during motions hearings, after the arraignment and prior to trial date. You'll go through a litany of motions hearings, one of them being evidentiary, and at that point, the defense generally will challenge the evidence in a particular case or the manner in which that evidence was obtained. Two things are necessary for bail: flight risk or a danger to the community. If the prosecution can convince a court that the defendant is either they can be prohibited from having bail, they'll sit in jail until trial date, or if they're a flight risk. Oftentimes, the flight risk is being dealt with now with ankle monitors, pulling passports and visas to not allow the defendant to travel or move around freely. Bail is a very important aspect to our system. You have a right to bail. It is incumbent upon the prosecution to prove to the trial court that you are either a flight risk or a danger to the community. Well, I think that covers most of what was in the week 2 quiz. I'm liking all your participation. If you go over the discussion questions, the supplemental readings, these videos, and the readings from your text, y'all should do very well in the final exam. in the last week. You'll have 5 days to take that. I know there's been some confusion, but you will have 5 days to take that test. Talk to you.